put on the gun prematurely.
I'm comfortable, Your Honor.
Okay. If you'll just let me know if you're going to reserve time when you start, I'm your timekeeper.
Yes, I'd like to reserve 5 minutes for rebuttal, please.
Great. Thank you.
Good morning, and may it please the Court. My name is Adam Knight, and I represent the appellant, Gloria Gass, in this appeal. The appellant argues that the trial judge entered the final judgment of foreclosure erroneously for 2 reasons. First of all, we argue that plaintiff failed to prove compliance with paragraph 22 conditions precedent found in the mortgage. And second, we argue that the interest amount contained in the final judgment was unsupported by any substantial competent evidence. Paragraph 22 of the mortgage sets forth 5 requirements that must be met before you can accelerate and foreclose a mortgage. First, the notice shall specify the default. The notice shall specify the action required to cure the default. The notice shall specify a date not less than 30 days by which the default must be cured, and the notice needs to specify that failure to cure the default will result in acceleration and foreclosure by judicial proceeding. The 5th requirement in paragraph 22 is that the notice must also inform the borrower of the right to reinstate after acceleration and further advise them of their ability to assert defenses in the foreclosure proceeding. The appellant challenges the sufficiency of the default letter in this case on 2 grounds. First, we contend that the default notice failed to provide 30 days within which to cure the default. And secondly, we argue that the notice failed to specify the default. As to the 30-day requirements, looking at the face of the letter indicates that there is a past due balance of $2,791 and some change. And it requires, in order to avoid the possibility of acceleration, that that specific amount be paid on or before March 31st, 2007. The letter was dated March 5th, and as such, the letter in and of itself on its face only provides 26 days within which the borrower can cure the default. Under cross-examination, the witness very clearly admitted that the amount that was in default on March 5th, 2007 was $2,791. The witness admitted that that payment was required to have been made by March 31st. As such, there is no compliance with the 30-day notice provision. And because they didn't give 30 days notice, they failed to satisfy the condition precedent to acceleration and foreclosure. And the reason why this 30 days is so important is because it's the borrower's last chance to avoid acceleration, and in this case, ultimately foreclosure. The notice provision is the only portion of the mortgage that is in bold, and it is intended such that the parties realize that this paragraph and these requirements must be met, have some level of importance when we go through and attempt to foreclose on someone's home. And for that reason, they should have provided 30 days. The inclusion of the next payment is just simply not allowed. And the reason why is because if we look at cases such as Singleton versus Graymar, those cases stand for the proposition that this is an installment loan contract. And under that idea, each separate payment is its own obligation. So this notice, when it requires payment of the amount due on April 1, it's tantamount to an acceleration. The amount that was in default was $2,791.79. The borrower has to be given 30 days to cure the default, not the default plus some that may or may not be due in the future. And that's the problem with this letter in that it only provides 26 days.
Can I ask a question?
Yes, Judge.
The letter is dated March 5th, 2007.
Yes, Judge.
And suit was filed on June 1st, 2007.
Yes,
So
Judge.
that's more than 30 days.
Yes, Judge.
Do you think the bank could have taken any amount up until that time?
The mortgage itself,
No.
The mortgage itself provides for reinstatement rights. The thing is, whether or not they filed the complaint outside of the 30-day window is of no consequence. And the reason why is because of the terms and the language contained in the letter itself. The letter says if you don't cure the delinquency, your failure to cure the delinquency will result in acceleration of your note and mortgage. So from a borrower's perspective, reading this letter, the letter says you got to pay by the end of the month, and if you don't, we've accelerated. And once acceleration has occurred, you have to pay the whole amount that's due. So it's for that reason that the failure to provide the 30 days in the letter itself is important. And secondly...
So your argument would be there where it said to avoid the possibility of acceleration, you must pay $2,791 by April 4th, and then a separate letter would be required for the payment that probably was missed on April 1st for that default because it's an installment contract.
A separate letter regarding the April 1st letter, I do not believe would be required, but I do agree with the court that regarding this letter, they had to be given 30 days to cure the default at issue. And the default that was at issue at the time of the letter was only $2,791.79. That's the issue. They had to be given 30 days at least to cure that specific default, which is not what this letter says. This letter only gives them 20 days. Of course, there's another payment due, and while a default letter could include payments that had been missed prior to the date of the letter and lump those into a single communication, I think that would comply with the terms of the mortgage. But to include the payment that is afterwards is tantamount to an acceleration. It's a separate obligation altogether. So when we look at this letter, they needed to provide 30 days as to just what's in default. For instance, let's say there's an insurance deductible dispute between the parties, and they send an insurance notice out. I don't think it would be appropriate to say that the insurance deductibles on your policy are outside of our compliance guidelines. You need to fix that in 30 days, but you also need to make the payment on April 1. That's just clearly a separate obligation. And I think that that's where the difference is. The second issue that we have with the letter is its failure to specify the default. And though the record generally alludes to a payment default and sets forth amounts that are owed and late charges and what have you, the letter does not tell the borrower what payment is in default. And that's an important thing because the paragraph 22 doesn't say shall state, shall provide, shall inform. It says shall specify. And in
What doesn't it mean when it says shall specify? It means specify the amount owed. You're trying, aren't you, in your argument, you're trying to say, well, it's not just specify the amount owed so that you know what to cure. You're saying you need to specify which precise month's payment was missed. Am I understanding that correctly?
Yes, Judge, I do think it needs to do that. And the reason why is because if we look at paragraph 22, the language of the mortgage itself sets that forth. The notice shall specify A, the default, B, the action required to cure the default. So setting forth the amounts that are owed with specificity would cure or comply with subpart B.
But they did set forth the amounts with specificity. I mean, I'm reading here from the letter. It says, unless the payments on your loan can be brought current by April 4, it will be necessary to accelerate your mortgage note. And it goes on, total delinquency amount, and then in bold states total due to cure default and bring loan current as of April 4, 2007, $4,074.02. Your failure to pay this delinquency will result in the acceleration of your mortgage note. What further specificity as to the payment needs to be made to comply with paragraph 22?
There is a distinction between specificity as to the default and specificity as to the actions required to cure the default. And the mortgage itself sets that out. Because in paragraph 22, you have subpart A, which says the notice has to specify the default, and then you have subpart B, which says that you have to specify the actions required to cure the default.
But the default is the default. The default is the non-payment, right?
I agree, but with each payment having its own obligation, it becomes important to specify which payment was missed. And the reason why is because if there's a genuine factual dispute between the borrower and the lender regarding what payment is missed, how's the borrower going to try to go back and verify based on this letter, well, which payment are they claiming I missed? How am I going to verify that with either my bank records or my account statements or what have you? And that's why the specificity requirement is there. The borrower didn't put that language in the mortgage. The bank did. They're the ones that required specificity when defining the default, and they're the ones that should have to comply with that requirement.
Does the paragraph say that the specificity requires identification of the specific month that has been missed?
No, it does not, but
or the specific, let's say that the note breaks it down in numbers. In other words, you have, however many it is, 534 payments that you have to make, that the notice must describe which numbered payment was missed. Paragraph 22 require that?
I think that would be more compliant than the notice that we have here. I think that the notice could have said, you have failed to pay your payment January 1, 2007 forward. I think it could have said if the payment was missed February 1. It could have said you failed to pay your payment February 1 and forward.
But this one didn't do that.
No, it didn't. And that's clear on the face of it. And that specificity is important, and it's what the mortgage requires. It's not some Herculean task for the bank to simply tell the borrower what payment was missed. It's not. And when you were reading through that letter, you read that the total to cure the default and the total delinquency was $4,074.02, but that's not accurate. That includes a payment that had not been due yet. The actual default amount was $2,791.79. And that's the amount that they required to be paid by the end of the month, which brings me back to the 30-day requirement. They didn't provide 30 days to actually cure this default. Excuse me. Our second point of contention is that the final judgment contained interest amounts that were unsupported by any record evidence. Specifically, it's a very narrow section of the transcript. It's pages 53 and 54 of the transcript. You can see where the witness confirms that the payment history that was tendered as an exhibit at trial, I believe it's pages, give me 1 second, it's pages 483 to 513 of the record. There's no evidence of the calculation of interest. This was an adjustable rate note. There's no evidence of the rate changes and how those occurred or when those occurred. There's no evidence of how the interest was calculated. And on page 54, the witness was asked, are they seeking interest? And he said yes. And he said, well, we're seeking this amount, but there's no record evidence of that. And the appellee argues that, well, we've waived that contention on this appeal, and I want to address that in two forms. First of all, this is a bench trial, and under the rules of procedure, you can challenge the sufficiency of the evidence even without a contemporaneous objection at the trial court level. And secondly, the witness was only asked whether or not they were seeking interest. If, for instance, if a plaintiff in a personal injury cases takes a stand and says, I'm seeking $100,000 in interest, or in damages rather, they have to prove that up.
I want to circle back to what you just suggested about Rule 1.530, which kind of sounds like a fundamental error in a civil case sort of issue. Would you agree that there may be some troubling negative incentives that the application that you are suggesting of that rule could create? In other words, that if you don't have to make a contemporaneous objection, counsel, in fact, could have an incentive not to raise an objection in order to then later raise it at appeal later on.
I would say that, yes, that could be used to gain a tactical advantage for appellate purposes. The problem is that's what the rule says. And we don't, at this point, the Supreme Court has set forth the rule, and if there is an issue with the rule as it stands, then the Supreme Court would need to amend the rule. But the rule as it exists today is that the contemporaneous objection is not required, and the case law interpreting that has followed the rule fairly substantially. I know one of the cases recently in a foreclosure context that looked at that particular portion of the rules was the Lacombe versus Deutsche case. It's not cited in our brief because we were a little off track where I intended to go, but
I do that every now and then.
So at the end of the day, the rule is what it is, and though it could be used to gain a tactical advantage, it can't, I suppose that would be possible under the rules as they exist. But at the end of the day, the witness said, well, we could have provided this other document. On page 54 of the transcript, the witness acknowledges that there is an interest calculation somewhere that could have been provided. It just was never tendered as part of the exhibits at this trial, and it wasn't even in court that day from what I understand. So at the end of the day, we look at the record and we have to ask ourselves, is there evidence of the interest that was owed? And there's not. And unless the court has any other questions, I'll reserve for rebuttal.
Good morning, Your Honors. May it please the Court. Dean Morandi from Carlton Fields Jordan Burt here on behalf of the Appellee U.S. Bank. I note that we didn't have any argument on the first point that appellant raised in the initial brief, so I will go ahead and rely on my brief for that. Moving on to the next point, which is that the letter fails to provide 30 days to cure. Well, I think the court already touched on the major points here. We have a default letter that specifies everything that is already due, and then naturally, this is a situation where it's a mortgage, a payment becomes due, so it includes the payment. If you pay after a new payment becomes due, naturally, that additional payment will be due.
The paragraph 22 is to cure a default, is that correct?
That's correct.
The payment that will come due has not yet come due, so there has not yet been a default, has there?
it will come due as of the first day of the month.
But if paragraph 22 is to notify you of a default and your failure to make a payment, can you notify someone in advance of that due date that you are in default when they have not yet breached? In other words, should this letter have only been written for the whatever payments were due as of the date of March 5th and said this is what you cure, and then if they default in April, will that trigger a duty to send out another
Well,
letter?
the problem is that wouldn't cure. If you paid on April 2nd and you paid $2,791.79, you would remain in default because your loan wouldn't be current.
Does not this loan allow your client to accept payments?
It does.
And did they not in fact do that?
They did that a year later, yes.
Okay, so theoretically, they would just require them to trigger another letter.
Well, no, because the default would not be cured. There was a default for the payment due in February,
I agree.
and that was never cured.
I agree. My concern is how can you tell someone they're in default before that event actually takes place and ask them to cure a default that has not yet taken place?
Well, we're not. It's
Well, you
to
require
cure,
them to-
see, the language here is telling. Total to cure default and bring loan current as of April 4th, 2007. Total delinquency as of 3/5/2007, the date the letter is sent, $2,791.79. If you want to bring your loan current before your next payment becomes due, that's all that's required. If you want to bring your loan current after the next payment becomes due, you would need to pay the entire amount. Now, if you paid at that point $2,791.79, you would no longer bring your loan current. I think a good way to think about this would be to think about the opposite. What if this letter didn't include that next payment? And what if the borrower on April 2nd paid $2,700.91? It's going to say, you sent me a letter saying that I cured my default, but you're still commencing foreclosure proceeding. What's going on?
Doesn't that prove Mr. Knight's point, though, then, that it is all the more reason why the bank needs to be very clear in its notice letter what payment is in default and what payment is missing?
Well, let's move on to that point. I don't think you get a whole lot more clear than this letter. Past due payments, $2,500 past due payments. So we know it's a payment default. We know it's past due payments, $2,564.46. Guess what? That is the exact amount of two payments that were missed. And the way the mortgage works, when payments come in, they're applied to what was previously due. So anybody looking at this is going to realize, hey, I missed two payments. I guess I missed the last two payments. And the borrower is in better position than anybody to know whether they paid that or not.
Well, operationally then, by including the next due payment for, is that April? There's really no
Correct.
30 days notice, or they shall provide not less than 30 days for the actual two payments that, as you mentioned, were in default, because if the letter's written for March 5th and you're telling them it has to be done by March 31st, there aren't 30 days to cure that particular default, which again, I guess we keep coming back, what do you have to specify
Well, no,
in the letter? You're using a default that has not yet taken place on April 1st
Right.
in order to give 30 days cure provisions for defaults that have already taken place. Isn't that
No.
what your operation of this letter is?
It's not. Well, let's think about this. It's $2,791.
Isn't that what it says? It says 30 days for the default.
Correct.
The default took place, as you've mentioned before, for two payments. You put them on notice for 30 days to cure. You're using 30 days by saying, by the way, I get 30 days because I can put the April 1st payment in there, go to April 4th, give 30 days, and by the way, no one's defaulted yet on April 1st.
It hasn't happened yet, but by operation of the letter, you haven't paid by March 31st. If you pay by March 31st, it's 27. If you pay after March
If you pay by
31st,
March
that
27th, you haven't got
2,700,
30 days then, have you? Your
No,
letter says
you
you can
still
cure by
have.
March 31st, but they didn't get 30 days under paragraph 22 to cure that default that you say you are in default of. These are your past due payments. You
Right.
didn't get 30 days to cure the past due payments, did you?
well, sure you do, because the past due payments are going to include what comes due. Naturally, it has to. What is the bank going to do? It's going to send a letter saying, oh, great, you've cured the default,
Bank
so,
can write it whatever it wants into its mortgage document. Maybe they
Sure.
want to write a better paragraph 22, or maybe have the U.S. government write a better paragraph 22 for them. Paragraph 22 says on its face what it says. You get notice for your defaults. Your letter says past due payments, which is a defaulted payments. You get 30 days for your past due payments. Past due payments, 30 days from March 5th is April 4th. You argue that If you pay on April 4th, you have to make the whole payment including April. Isn't the operation of this paragraph 22 is you get 30 days to cure the past due defaulted payments, and that would be April 4th.
April 4th would be 30 days, right?
Correct.
From
But the letter says you have to pay the defaulted payments by March 31st, which is considerably less than 30 days.
You're getting 30 days to pay the default, but that's adding in there what you're contractually due for the next payment.
And it's that adding in, I think, that's troublesome.
Well, I think it has to be this way. You have a mortgage where you know, everybody knows, that the payment is due on the first of the month. To suggest to the borrower that you've cured your default by paying on April 4th only $2,700.
But they had. Hadn't they cured the default? If they paid
no, because
let me finish. If we buy Mr. Knight's argument that each payment is a standalone obligation, and they were in default for, let's use your assumption, they were in default for 2 past months' payment, and they paid that by, I forget the operative date now, but if they paid just that amount, they had cured the default. Now, they may not make the next month's payment, in which case there is now a new default. Again, if we accept Mr. Knight's argument that this is each state, in which case the bank must now give another notice that, hey, now you've missed this month.
the bank needs only give one notice of default. If that default is not cured, you don't need to give subsequent notices. If April 2nd rolls around and you have not made your monthly payment, you're still in default.
And you're entitled, under paragraph 22, to 30 days.
That is not, go ahead.
You don't believe that that's correct?
I do not.
That new default would give you a right to have, let's assume this scenario. Let's assume the borrower had paid just the $2,700, but then missed the subsequent month's payment. You wouldn't argue that the prior notice could be used to give notice and cut short the amount of time that the borrower would be due on that second one, are you?
You are correct. If they paid $2,700 before the next monthly installment payment was due, they're cured, and then a new default letter would have to go out.
Okay.
If they do not pay by April 2nd, and they only pay $2,700, they remain in default, and no new letter is required. That would be...
They remain in default for a newly arisen default that they cured?
Because the loan's not current. The loan is not current. If you look at the language of paragraph 22, if the default is not cured on or before the date specified in the notice, lender at its option may require immediate payment in full of all sums secured by the security instrument without further demand. Without further demand. So you're looking at a letter where everybody understands they have a monthly payment that's going to be due. You've defaulted by not paying. The loan is in default. You have another monthly payment coming due. It makes no sense to not include that subsequent monthly payment in here, because you're going to remain in default the entire time. You're not going to cure your default by paying only $2,700 when you've got a new monthly installment due. It would be, I would argue it's potentially misleading to not at least let the customer know, or depending on the language that you use in the letter. You're telling the customer, okay, you've cured your default, but guess what? We're going to foreclose anyway because you never brought your loan current. That certainly doesn't make sense.
Arguably, you would have to send out another letter for the next default
As I
before
said,
you could accelerate.
that's not true, because the loan, the default was not cured.
Don't we take a look and see what the words are used? Paragraph C of paragraph 22. A date not less than 30 days from the date the notice is given by which the default must be cured. And your letter tells you which payments were defaulted, the 25 plus the interest with the 27. That's the payments that are in default, for which you should get 30 days appears by the bold letters used in this approved paragraph 22, which has spawned so much litigation.
Yes.
You know, it's much like the offer of judgment rule, you know. You think you're going to reduce work, and instead it's creating work.
Right.
But if we use the words that were used, we talk about the default in this, as your letter says, is those two payments. You get 30 days to cure that default. And it says not less than 30 days. Now, you may be absolutely correct that it's not logical. I'm not prepared to debate that with you. But my concern is, what does the agreement that these parties signed provide, and what is the language used in it? If it says cure the default, that means that default must exist at the time the notice is. To me, that's logical. It's temporal. There's a timeline. You are
Right.
in default for those two payments. You get 30 days to cure those two defaulted payments. A payment that has not yet accrued yet arguably can't be in default.
That's true. But it's going to be in default if you don't pay by the time it's due.
Granted.
That's the problem.
And would they
You
get,
can't tell a
under
borrower-
paragraph 22, would they get another notice that says, you have just missed another payment, you have 30 days to cure? It doesn't make sense from the bank's point of view, because then you can get a borrower who's constantly being late, constantly requiring you to send a notice. I understand it. Doesn't
Exactly.
strike me as being logical in the business sense, but in terms of the language that they used, if we give it its ordinary meaning.
Well, let's step back for a moment and think about what it is that this letter is doing for the borrower. It's giving them notice of their obligations and an opportunity to cure. They're supposed to have 30 days to cure their default. Well, guess what? You've got 30 days to cure your default, and what's included in that is if you don't pay by X date, you're going to have this additional amount to cure the default. That's what this letter is about.
Was there an
There's a-
attempt to cure this particular default? Whatever it was that was particularized in the
None.
letter?
Well, let me back up. None for almost a year.
Okay.
We have the letter, we have nothing being done, we have 88 days going by, and then we file suit. That could bring us back into the substantial compliance doctrine. I think that the letter as written complies under any standard, but at a minimum, this substantially complies with what Section 22 is requiring. We have 88 days where nothing was done. Again, about a year later, there were 3 other payments, but that's not relevant to the issue here. So again, I think this letter would even strictly comply with the requirements of the mortgage. But if there were even any question, if you're suggesting that somehow the letter is made more logical than perhaps the words allow, that's at least substantial compliance with the requirements of the mortgage. And unless the panel has any further
Don't forget
questions.
the second issue that he raised orally. You still have
Oh.
7 minutes. There's another issue.
apologize.
We have been occupying you on one, but don't forget that
Apologize.
second
Thank you, I
one.
appreciate that. Going to the prejudgment interest issue. Again, I can see the court has a pretty solid grasp of the issues there. Our witness testified without objection. There was no motion to strike. That in itself is competent substantial evidence. The figures in the proposed judgment comport with the evidence. It was on page 33, 54. He says, in preparing the judgment figures, I broke down the interest rates, and I came up with $60,125. That of itself is competent substantial evidence to support the interest calculation. One other point is that if you look even in the record, even put that testimony aside, there's still competent substantial evidence in the record to support the interest calculation. There's an adjustable rate rider in the record on page 317. Goes into detail on exactly how the interest rates are calculated. It's based, it has everything. The interest rate begins at 8.99%. The rate can change on July 1st, 2008, and every 6 months thereafter. At that point, the preceding month's 6-month LIBOR rate, as published by the Wall Street Journal, plus 4.375% will be the interest rate. And there's also a proviso to say that it cannot go up or down by more than 1 percentage point every 6 months. Using the principal balance that everybody, I don't want to say agreed to, but using the principal balance that was determined at trial, you can use this, and I came within $5 of figuring out what the accrued interest is. And that's clearly what our witness did at trial. He just didn't show his work. And he didn't need to, he wasn't asked about it. This is all publicly available information. And again, unless there are any questions about that,
Well,
I
as
appreciate it.
Judge Lucas is bringing out, it seems to be that this Rule 1.530 provides counsel an absolute opportunity to sit quietly and not tender an objection that could be cured at trial.
Well-
And now all of a sudden we're asked on appeal to say this is not competent substantial evidence because it would have been inadmissible hearsay, and it seems to fly in the face of what many of us understood. If inadmissible hearsay is inadmissible when you object. It's not
Exactly.
inadmissible once it's admitted.
Right, and I think, well, I think that's our position. This isn't the situation where, this doesn't obviate the need to contemporaneously object to evidence coming into the court, coming into trial. It's worth noting here that evidentiary objections have to result, or evidentiary issues, things coming into evidence, have to result in a miscarriage of justice to warrant reversing a final judgment. Here we have a number that came into evidence. We didn't have any discussion of how exactly it got broken down, what the interest rate changed to every 6 months, and what the interest came out to be, but nobody's saying that that number is incorrect. Nobody tendered opposing evidence.
Was this the bank's witness?
This was the bank's witness.
Was he cross-examined on that point? Was there an opportunity to cross-examine him on that
There
point?
was an opportunity to cross-examine on this point. There wasn't a great deal. I think, I want to say there was one question, or maybe one or two questions, directed specifically at the prejudgment interest, and I think that's on page 54 of the transcript, if you wanted to take a look at that. So there was certainly an opportunity to go in depth about where these numbers came from. He did say he didn't have the paper in front of him, but he could have said, okay, well, where did the numbers come from? Well, if you want to show me the adjustable rate rider, I'll show you where they came from. So there was that opportunity to do that. And if there are any additional questions?
Thank you.
Thank you, Your Honors.
If I may, I'd like to start with the interest issue. Your Honor asked whether or not there was an opportunity to cross-examine. If you review the transcript, on direct examination, this witness never testified whatsoever as to the interest calculations at all. There's no testimony in the record from pages 1 to 33 regarding whether or not the interest calculations were calculated by this witness, how they were done, et cetera. It was only on cross-examination that there was inquiry as to the amount of interest due. And on page 50, excuse me, page 54 of the transcript, I asked a very simple question: are you seeking interest? I did not ask him the amount. He says, yes, there's current interest of $60,000 and change. The problem is that's not evidence. I didn't ask him what the interest amount was. I didn't say, have you calculated the past due interest amount and reached a conclusion? I said, are you seeking interest? His statement of what the interest balance is not in and of itself
Well, arguably, it
evidence.
wasn't responsive to your question. Was there a motion to strike that testimony?
No, Judge, there was
So
not.
it remained before the trial court?
His testimony stood before the trial court. My point is that there's a difference between what a party seeks and what a party proves. As I explained before, if I'm called as a witness in a trial and I'm seeking damages, I can say I am seeking $100,000 in damages, and that's fine. But that is not evidence that my damages are actually $100,000. It's up for me, if I'm the plaintiff, to present evidence that those damages match what I'm actually seeking.
But upon hearing that testimony and recognizing that what he's responding is testimony, I mean, it's fair game evidence to be considered, doesn't the trial lawyer at that point have one of two options? Either move to strike it, because, wait a minute, Judge, that's not what I asked. I just asked if they were seeking it. Move to strike, either as non-responsive or as not based upon any competent basis, or if you want to go down the path, flesh it out further. All right, you just told us an amount. How did you compute that amount? And then we have a reasonable means for the trial court to delve into that, and for us on appeal to review it.
I agree. In retrospect, I was trial counsel, so in retrospect, yes, a motion to strike may have been appropriate, but the question is whether or not it was required under the rule, and I don't think it was. In this case, his testimony that they are seeking an amount of interest is not in and of itself substantial competent evidence of the interest amount. Counsel points to the fact that there's an adjustable rate rider as part of the record. The problem with that is it's based on the LIBOR index. I don't know what the LIBOR index is in terms of what it was on a particular date and time.
You don't check that every morning?
No, I do not. And this witness didn't testify as to it either. And that's the problem. Because it may adjust, you still need to know what the adjustments were and what the amount of the adjustments were. Counsel said that he was looking at it and came up to a sum within $5. The problem is, this is math. It should be exact. It should not be a sum within $5. It should be the exact amount. And if you can't reach that amount, then there's a problem. And that's why there's no substantial evidence to support this. He also stated that the witness that talked about calculating the interest. You can review the transcript. The sole testimony regarding the interest amounts is found on page 53 and 54. There's no evidence where this witness says, I looked at the figures and I prepared all this stuff. He said he prepared judgment figures and provided a breakdown of the changes. He does not say that he personally calculated this stuff. So his testimony is just not evidence of the interest amount. And I'd like to come back to the 30-day notice provision. The court seemed to have some concerns about this, and I share them. Specifically, you said adding in the next payment is troublesome, and it is. And it's because, I'll use the example that Appellee is using. Say there's a payment on April 2nd. If there's a payment of $2,700 and $2,791 in the change on April 2nd, the question was, does it cure the default? And Appellee's position was, no, it does not. We think it does. And the reason why is because that letter, when it was sent on March 5th, had a very specific default amount. And if you pay that amount within the 30 days, and if they had given her 30 days to pay that amount, it would have cured that default. And whether we like the terms of the mortgage or not, that would have triggered the requirement to send a separate notice relative to a potential failure to make the April 1st payment.
And can you then address the concern that was also raised here, I forget which one of us raised it though, along the lines of all well and good, but factually in the record that we've got before us, there was no partial payment. In other words, if this had been an appeal set up where your client, the homeowners, had made that $2,700 and then the bank jumped the gun and still put them in for, filed their lawsuit based upon, well, you didn't comply with the notice, wouldn't we have a better case to resolve that? Whereas here, it's really not an issue because they didn't pay anything toward even what I think you would recognize. There was a separate line item that said this is the amount in default, and there was no attempt to cure that.
It doesn't make a difference whether or not there was a partial payment. It may be a cleaner case, it may be a morally or an ethically superior case, but from a legal perspective and a contractual interpretation perspective, there is no difference. This mortgage is very clear. It is in bold, in black print, and it says the notice shall specify a date not less than 30 days to cure the default. That is the notice that this borrower was supposed to be given when there was a default. It does not matter whether the complaint was filed more than 30 days out. It does not matter whether or not a payment was made. What matters is what the parties bargained for at the time of reaching this contract. And that is what they bargained for, a 30-day notice provision.
Is your argument, and I'm not trying to pigeonhole you, but I'm going to try to pigeonhole you. Is
Please.
your argument that the default notice simply doesn't comply with paragraph 22, or is your argument that it is ambiguous and therefore doesn't comply? In other words, is your argument that this notice does not give notification of default, or what the default is, or is it's ambiguous as to what the default is, and therefore that ambiguity renders it non-compliant with paragraph 22?
I think it's both. So I'm going to try to get out of that pigeonhole a little bit. As to the specification of the default itself, I do believe that it is ambiguous at best, and that means it doesn't comply. And it doesn't comply because the requirement is not shall inform, shall state, shall provide. It is shall specify. And in our brief, we've gone through and we've looked at the cases and we've defined what specify means. But when you're specifying something, you need to state with exactness, preciseness. There cannot be confusion. And this letter doesn't comply when defining the default in that regard. And because of that, counsel represented that, well, this is exactly 2 payments. Well, how do we know that? It's an adjustable rate note, and the payments that were due preceding those dates at page 512 of the record were $1,346.34. So at that point, if we multiply that by 2, that would be a little over $2,700, which doesn't match the amount that they have in the letter. So at the end of the day, it's not so simple as to say this is exactly the 2 past due payments. And it's also, counsel inferred that it would be misleading to not include the next payment in the default letter that's provided. The problem with that is you can't argue it's misleading to not include the next payment, but then say at the same time, well, the borrower's in the best position to know that they have a payment due on April 1. Well, at the end of the day, the bank is in the best position and is a superior position when it comes to preparing its own letter. And its own letter fails to provide 30 days.
I need to let you know, unless there's other questions, your time has expired a bit back.
Thank you, Judge. We rely on the merits of our brief.
Thank you both. Appreciate your patience with us and your responses.